the Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, September 18th, 2023, although you won't be listening to it for a little while. But that's okay, because this is not a late-breaking podcast about the latest from the federal courts of appeals, as we usually have here on Short Circuit, but this is a bit of a more timeless area of law, where we're going to be talking about something very near and dear to our hearts here at IJ, and that is the Fourth Amendment, but also something a little bit more nebulous and mysterious, but something that I take a great interest in, and that is the general law. And so to that end, today we have a special episode with a special guest who is co-author on, conveniently enough, a piece called The Fourth Amendment and General Law, published earlier this year in the Yale Law Journal. It's a pretty good place to land a publication. Now, he published this along with his colleague, Danielle D'Onfro, who is also a professor at Washington University at St. Louis School of Law. And so I'm very pleased to introduce you to Professor Daniel Epps. Now, Dan is the Treeman Professor of Law at Wash U. He also has numerous accolades, has been published in all kinds of wonderful places in addition to the Yale Law Journal. He also clerked for Justice Anthony Kennedy and has been a longtime podcaster, and you will know him from the currently going podcast Divided Argument, which is a unscheduled, unrehearsed, much to my chagrin as someone who has a scheduled podcast, podcast about the Supreme Court that he puts on with his co-host, former IJ clerk, Will Bode. Will is now known for a few bigger and better things than being a clerk at IJ, including the stuff about Section 3 of the 14th Amendment that people have been buzzing around the last few weeks. But we're not going to get into that today. Instead, it's all about Fourth Amendment and general law with Professor Daniel Epps. So Dan, welcome to Short Circuit.
Thanks for having me, Anthony. And I'm pleased to know that my work, recent work, is already considered timeless.
That's right. That's right. It'll never change because I think it set the authoritative statement on the Fourth Amendment and general law. Now, be that as it may, the Fourth Amendment very much has been in flux at the Supreme Court the last few years. There seemed to be, ever since Justice Scalia, in my view, in a very good decision in 2012, I think it was, with this case called Jones, kind of set everything anew on what's possible with the Fourth Amendment. And since then, people have been trying to figure out, including the justices on the Supreme Court, how the Fourth Amendment relates to our stuff, for lack of a better word. And so you are kind of part of this ongoing conversation about how to think about the Fourth Amendment in this new phase of its history. So give us a bit of an overview as to, what that history is and what the debate has been and where you see yourself in it, and we can go from there.
Sure. So in terms of the history, you kind of have to go back quite a ways. And there's a little bit of disagreement about what the history of the Fourth Amendment looks like, but I think we can go back a couple hundred years and say the main way, you have this provision in the Constitution that protects against unreasonable searches and seizures. There's a lot of disagreement about what exactly that means. But in terms of how these things once worked, normally you would go, if you were, the victim of an unreasonable search and seizure, you would sue somebody in, say, state court. You would just bring a kind of trespass action and say, hey, you trespassed. And if it was unreasonable, the constable or whomever couldn't maintain a defense. And in theory, the Fourth Amendment kind of continues to allow those kind of suits to happen in that backdrop. But fast forward, more than 100 years into the 20th century, Fourth Amendment protections look very different, right? They're now enforced primarily as motions to exclude evidence in criminal cases. So evidence has been found, inculpatory evidence, and someone is saying, yeah, this evidence looks bad, but it was taken in some way that was unreasonable, violated, there was no warrant, it doesn't, for various reasons. And so for that reason, it should be excluded at my trial. And so that develops, and then around the middle of the 20th century, the court says, well, we need kind of a test to figure out, what actually counts as a forbidden search and seizure. Prior to that point, and again, this is where there's some kind of disagreement, or Kerr has kind of pushed back on this. But the conventional view is the court kind of looked to property rights, sort of said, did the police, intrude on your property rights? Did they commit a trespass in this conducting the search and seizure? And if they didn't, it's not necessarily a violation. But then in the middle of the 20th century, the court starts saying, what matters is whether what the police did intruded, violated a reasonable expectation of privacy. So you had to have an expectation of privacy that society is prepared to treat as reasonable, and that's kind of the test for whether, formally, that's actually the test for whether there is a search or seizure at all, which is kind of doesn't make a lot of sense conceptually, but put that to the side. But basically, that's the test for figuring out whether the police action at least implicates the Fourth Amendment and possibly violates your rights. Court has continued to adhere to this over the decades. It is pretty widely criticized, and one of the main criticisms is it's totally malleable. It's not really rooted in anything. It's kind of circular because the kinds of privacy rights we treat as reasonable are kind of the ones the court has told us are reasonable. And there's been a kind of struggle to figure out if there's something better. And you teed up what I would say by referencing Justice Scalia in Jones and in some follow-on opinions to that sort of later in his career. He had been kind of a critic of Katz, but hadn't quite fully developed an alternative.
Katz being the reasonable expectation of privacy case, right? That it kind of
sorry, I should have said that earlier. Katz is the case that lays out that test. It's a case about basically surreptitious recording of a conversation in a phone.
Listeners'
booth.
benefit is KATZ. Unfortunately, it has nothing to do with felines, but that was the fellow's name in the case.
Although it Orrin Kerr, when probably the leading scholar of the Fourth Amendment these days, has chronicled the number of bad puns in student law review notes about Katz. So he's got a list somewhere published in the Volokh Conspiracy blog. So Google that. They're pretty.
We'll put a link up to that in the show notes. I think our listeners.
Oh,
will
great.
Enjoy.
Okay, that's all the better. And so he starts saying this reasonable expectation of privacy test, aka the Katz test, just doesn't make a ton of sense. It's kind of just made up. All we're really doing is just saying, you have Fourth Amendment protection in stuff that the justices like. Right. Basically, we're not actually looking at what society thinks is reasonable. It's just an inquiry into, what justice is like and what we think is reasonable. It's not rooted in anything. And so he starts saying that, but he doesn't clearly say what we should be doing instead. He starts to flesh that out a little bit more, and he starts saying, well, we need to look at kind of we need to look at kind of traditional property protections. And he does that in some cases. I'd say he doesn't give us at any point a really full theory, right? About, are you looking just at the specific law of trespass that's codified by statute in Maryland and the District of Columbia if the search occurred, the GPS tracking, which is at issue in the Jones case, if it occurred in those states? Are you doing something else? Are you looking at the positive law, the property law that would have existed in the U.S. and England in the late 18th century? Unclear, and I think that's the kind of thing that he would have continued to develop had he been on the court another decade or so. But he kind of plants that seed, and a lot of people find that intriguing. And different people have gone with that in different directions. One approach that our paper engages with a lot is one by my podcast co-host Will Bode and good friend of mine, James Stern, called the positive law model. It sounds like you've already talked about that on the show, possibly a little bit.
Here and there, yep.
At least averted to it. The idea being that whether police action implicates the Fourth Amendment turns entirely on what the positive law of the jurisdiction where the action occurs says. Is this something that a private party couldn't do?
And by positive law, you mean like it could be the common law, it could be statutes, but if like whatever the actual law is for that jurisdiction, that's the law.
Yes. The actual law of that jurisdiction, you have to go say, what does Maryland say about this?
Right.
And you got to look at Maryland courts and the Maryland code and maybe like the Baltimore City Code or, the stuff that actually is legally operative in that jurisdiction. And it's a really good article that they wrote in the Harvard Law Review, The Positive Law Model of the Fourth Amendment. I think it's one of the best Fourth Amendment articles in a really long time. Really provocative, really interesting, creative, really changes the way you think about this stuff. But it also, creates a bunch of, practical problems. Do the rules change the instant you drive over the border between a different city? There are all sorts of complexities that I think they don't fully work out and don't have fully satisfactory answers to. And I think as clever a theory as it is, it strikes me, and I think it strikes a lot of other people, as something the court is never going to fully adopt. But more interestingly, it's something that I think is not what Justice Scalia was aiming at, and it's not something that the court today, the court historically has ever really done. And so what our paper tries to do is kind of, ride the wind from Justice Scalia's criticism and some more recent work by Justice Gorsuch in a case called Carpenter, which is about tracking location using cell site location. So basically looking at information about where someone's cell phone moves and when it's connecting to cellular radio towers. And we say, the general idea that Justice Scalia had that you look to kind of property law protections, that's the right idea. But you don't go pull out the Baltimore City code and the Maryland code and things like that. You can look at those things. Instead, you do something a little different. What you do is you look to general law. And here we're relying on a lot of really interesting work by some, sort of originalist-minded scholars, historical scholars. Caleb Nelson. Will actually has written about the general law in other places. But what is general law? General law is basically the kind of common law that kind of exists, but is not under the formal power of any one jurisdiction. You kind of are, it's exactly kind of, if you were trying as a court to kind of just figure out like what is the kind of the right common law answer to a question and, we're not bound by a particular statute, how would you do that? How would courts do that? How have courts done that historically? They look at a bunch of different sources. They look at the practices of different states. They look at customs and so forth, and they try to come up with the best answer. We are not doing, it's not really an originalist paper as such. We kind of make some arguments for why this is actually much more consistent with the way the Fourth Amendment would originally have worked, that you would go in to court and you would bring a common law trespass action, as I said. And the way that those typically would have been understood 200 years ago would be not as this, sort of purely positivist, what does this exact jurisdiction say, but as an inquiry into the general law. What is the general law of property, trespass, and so forth? It's a little bit more complicated than that. There's a lot of wrinkles there that I don't want to get into right this minute. But we think that this is the right approach, that when confronted with a question of uncertainty about the scope of the Fourth Amendment, does this thing that the police did, is this something that the Fourth Amendment says something about? Maybe it requires a warrant for. How do we figure that out? We say, you engage not in this kind of fuzzy privacy analysis. You look to whether this is something that, the kind of action that would, at least prima facie, implicate the general law, violate someone's rights under the general law. So the general law of property, this thing that the police took possession of, would this be something under the general law would have been treated and that would continue to be treated under the best reading of those principles as a bailment? Would this be a trespass under general law? And I think one thing that's quite compelling about our approach is that it's actually much more consistent with what the court has done and with what Justice Scalia was doing in the cases where he, kind of defended a property-based approach. In those cases, he was not looking at the specific rules applying in any different jurisdiction. He was sort of asking, is this a trespass under general principles? Is there an implied license for police to bring a drug dog to someone's front door to kind of sniff? And he doesn't look at sort of jurisdiction-specific rules. He asks this more general question about the kind of customs and habits of the country. In the case where he talked about that, that's a case called Florida versus Jardines. And we think this is a better approach for a lot of reasons. We think it has better justification in history. We think it's much better justified by precedent of the cases that do moves like this. And we think it's much easier to apply than something like the positive law model, which causes protections to kind of radically change depending on specific rules as you cross over city boundaries and so forth. This would produce, we think, national rules because Fourth Amendment courts and Fourth Amendment cases would say, look, I can look at what the property law of Maryland says, but ultimately this is a question of federal constitutional meaning, and we think that the scope of the protection shouldn't be, totally controlled by what this particular jurisdiction has done. Instead, we think the scope would always have been understood to be kind of a question of general law, and we're going to do that. We're going to do the traditional tools of the common law, which, looking at these kind of broad concepts that come from the original common law, but it also can include creating new and recognizing new kind of common law rules. So it has a fair amount of flexibility, but is a little bit more tied to kind of law, at least we think as a formal matter, than the kind of freewheeling cat's reasonable expectation of privacy test.
Law that's tied to law has a certain ring to it.
Yeah. But I would just say that, but a lot of people have this aversion, right, to this idea that you can have law that isn't something a legislature said.
Right.
Right. We have this view kind of post Justice Oliver Wendell Holmes that there is no such thing as a brooding omnipresence in the sky. There's only the kind of positive commands of any given sovereign. And I think that some of the work that we're really leaning on in recent years has said, no, that doesn't have to be true. There are things that we can kind of treat and recognize as law, without necessarily saying that the specific rule has to have been written down by sovereign. Instead, it can be perfectly consistent with law to sort of say what is supposed to happen here is courts are supposed to look at kind of general practices and sort of try to recognize what the rule is that comes out of, social custom and tradition and, insights that have been recognized by other courts.
Well, I want to get the very much the idea of law without a sovereign in a moment. But for our listeners' benefit, what's a couple examples of like how this might play out in the real world beyond the couple cases that Justice Scalia was involved with, the dog sniff case and the GPS on a car case? But what are a couple other examples where you got to look to property law for what the heck the boundaries are, what private people could do or what the government could do, and then how would that affect a court looking at the Fourth Amendment?
Sure. And so, I think one selling point of our theory is that this is not like a radical change in terms of results. Actually, if you look at it, probably a good number of the CATS cases, of the reasonable expectation of privacy cases from the last 60 years or so, are kind of asking the kinds of questions that a general law court would ask. They're just using the kind of wrong vocabulary, the wrong tools, and they can sometimes be led into error that way. So we don't say like, here's this completely radical change. But so, just to sort of take one small example, a couple small examples, there are courts that have said that, if you kind of like leave your apartment and, it's clear that you don't plan on coming back, you've kind of fled, that you have abandoned your privacy expectation.
Even if you still have a lease, right?
Yes, even if you still have a lease.
Yeah.
And as we talk about, that's just not consistent with traditional property understandings, that you maintain property rights in that location while you have some valid property interest, a lease, you're the owner, and so forth. Right. And so, privacy isn't really the answer to the question. Maybe you do expect someone to break into your apartment. I don't know, but that's not the right question. The question is, do you have, a expectation, does property law give you a grounding and a right to kind of object to when the government busts into your place? Likewise, there are various cases, that involve kind of movable, tangible property. And we talk about how bailments, the law of bailments, Danielle has actually written separately about kind of reviving the law of bailments, this traditional common law rule governing movable, tangible property, that there's a lot of rich content there that could provide some guidance, both in cases involving physical property, because we show that a lot of lower courts have kind of approached questions about movable physical property using a kind of ill-fitting cat's approach. Do you have real expectation of privacy in your jacket or something like that? And we say, no, the rules, there are some pretty firm, well-established rules there that govern, what are third parties' rights vis-a-vis a particular in their piece of property that you've left somewhere. How much do you as the owner still retain your rights? And there's this rich law there that actually looks different. It provides in some ways more protection than this property approach. But we also talk about these concepts can be extended to other forms of property. That there's ways you can think about information that you have given to Dropbox as a bailment. Yes, they are the physical holder of your files, but the right way to think about that from a general law perspective is they are just a bailee. You are the bailor. You retain your property interest in the files. They're holding them for you. They have certain obligations and so forth. As a matter of civil lawsuits, maybe you've had to sign various waivers or so forth, arbitration clauses, who knows? But as a matter of general law, that's the kind of property relationship that we think would have prevailed and we think provides, a fair bit of guidance and flexibility and kind of the right conceptual toolkit for dealing with not just traditional situations, but these new situations that the Fourth Amendment and I think the Katz test is really struggling with these days. Yeah.
So let's get into that, the bailment and maybe the contract aspect of that, because I see that as kind of the most, might be the biggest change from current doctrine. And I think it's a change that a lot of critics of the court have wanted, your podcasting co-host included, that currently under Supreme Court doctrine, what's called third party doctrine, if someone else has your stuff, is in possession of your stuff, you don't have much standing, as they call it, to object to the government getting that stuff. Maybe that third person does, but maybe the third person, of course, doesn't have as much an interest. But maybe you've signed a contract, like whether it's your bank or a safe deposit box, like a case we have at IJ right now, or something else, where you have a contract with that person who said, yeah, I will look after your stuff. I will object to searches of your stuff. And then the police come in and you can't enforce those rights. So with that in mind, we have this Carpenter case from a few years ago, that the one with the about the cell phones that you talked about. And Justice Gorsuch it's technically a dissent, but it's kind of a concurrence in the case where he's like, hey, I like this new idea about property rights, but guys, I don't know what to do. And like, should we look at contracts? Should we look and he's basically inviting, lawyers to come up with arguments to try to convince him. So what intrigued me about your idea is it takes those contractual rights seriously, but it's like it doesn't really exactly depend on, having to look at the fine print of every single contract when a court's looking at the Fourth Amendment. Do I have that right?
That's absolutely right. And we think that would be kind of just administratively, deeply impractical. And so, just more generally, one thing that I have long believed, and I've said this to Will, I was like, this is a great theory, a positive law model. It's just never going to happen. The justices aren't going to like it. They want to be able to make national rules. Courts want to be able to make rules that apply. And so our approach lets you make those kind of more general rules. But your description of Justice Gorsuch's, quote, dissent, unquote, is exactly right. And we sort of frame the introduction to the paper as kind of an answer to his question, because he sort of said, like you said, it's phrased as a question, like, do we do this? Do we do that? And we say, look, Justice Gorsuch says, do we look at the positive law today? Do we look at what the law was in 1791? And our answer is neither, right? You do something different, but something that's actually very compatible with what he's trying to do, what he seems inclined to do. And so, the paper, we think, is not just a kind of brief addressed to him, but he provides a really nice articulation, crystallization of the question going forward that justices drawn to his approach are asking, and we think it provides like very satisfying answers to those questions.
So I haven't read all of the back and forth from your paper and your critics and those you discuss, but I have seen that there's one quibble has been that you have this idea about the general law, would quote, I put quotes around general law because we get into how that might be different than what most people think about the general law and legal scholarship, what it is today. And then there is an argument, though, that the Fourth Amendment, as it was understood or would have been understood and when it was adopted in 1791, is that unreasonable meant not according to the common law, whatever the common law was back then. So I could see how if you're looking at, computer hacking or something like that, that's not going to help you at all. But if it's something more clear, say what the common law was in 1791, and everyone says, yep, well, Blackstone said that's the law, and everyone believed it was the law, and yet it's changed to the period we have today. Does that provide some, breaks on how you would look at interpreting the Fourth Amendment? Because at that point, it seems like you're kind of rejecting the common law that the Fourth Amendment itself was referring to. Or is there not a problem there?
Well, I think that presupposes the answer to the question of what the Fourth Amendment was trying to do. It is one of the options on the table to just say the Fourth Amendment was meant to take the common law rules that existed at that time and just kind of, those are the rules, right? Those are the rules we're stuck with. We criticize that approach because we say that's not the way the generation that drafted, ratified, believed in, endorsed the Fourth Amendment would have understood the kind of protections of the common law, that they weren't just this fixed body of rules that were never going to change for all time, that if, the kinds of ways in which these cases were brought and enforced, you would have, courts would have looked to the general law. But also at the same time, the understanding would not have been the general law is whatever a court says it is, right? That's what we think today, right? We think the common law is this is just a delegation to courts to make up the rules. And that's not the way it would have been understood either. It would have been understood as, there are answers out there and you look to various things, and the common law can change in the sense that, and this is something, Blackstone would have believed, that a court can recognize it got something wrong, right? That there was an earlier answer to a question about common law, general law that then changes, but it's not necessarily because the law changes. It's maybe because that answer was always correct and it wasn't fully recognized. Courts can make mistakes. But we also we think it doesn't make sense to say that by, drafting, ratifying, and so forth, the Fourth Amendment, the idea was to completely, to not provide any protection for kind of other kinds of situations that would arise in the future, right? That basically it only governs, the kinds of physical intrusions that would have been considered trespasses under property law a couple hundred years ago, and I think that's there's a real problem with that if you take that view. And this is something that Justice Gorsuch sort of alludes to, although he's talking more about cats. But it is a world where we just care about things like that. There's not going to be much left of the Fourth Amendment because all of our privacy is, the stuff that we care about, all that information basically just resides on computer servers.
Right.
And the government can potentially get basically every detail it wants to about our lives without ever setting foot in our houses, without ever laying a hand on us. And maybe you could take the position that it really just is about those kind of traditional physical trespasses. We certainly think that wouldn't be consistent with the spirit of the Fourth Amendment, with Fourth Amendment values. And we also don't think that would have been consistent with the way that generation would have understood the law. That this idea that the common law is just this set of rules that courts have come up with, and does that create the possibility that the specific rules might look different today depending on how courts approach the question? Sure, that also is a problem with the prevailing Katz test. It's also a problem with the positive law model because a legislature can go change the positive law rules tomorrow, and we also, at the same time, I think we say, we would approach things with a fairly strong presumption that, what counted as a physical trespass 200 years ago is not super likely to change, right? Even if our approach sort of says, look to the general law today, we don't necessarily see great, arguments that that's going to be radically different today. And so in practice, I'm not sure it's going to be that much less protective, if at all, than a kind of approach that we sort of call in the paper that freezes the rules in amber, 1791 amber, that's exactly what the common law rules are, and they can never change, even though they had kind of evolved and developed and been extended, by courts up until that point.
Well, let's get more into that common law and then in the general law. So one reason that I really enjoyed your article and the discussion of common law by you and Danielle is that I haven't read Danielle's other scholarship. I haven't read much of yours either, but you guys don't strike me as like Friedrich Hayek, uber libertarian, like anarchist types, right? Which is people more like myself who often get into the whole idea of spontaneous order and the creation of law and law without a lawmaker and all that, and that some of our listeners may be familiar with those arguments. You take seriously the idea of law that is just kind of generally the law of the land, even if it's not made by legislatures and statutes, but you use it in a very practical way, which is different than most of the literature in this area. So with that kind of practical background, tell us a little bit more about what you mean by the law, kind of as the general common law, majority rule common law, you might call it, and how that's different than, or maybe it's to some extent the same thing, what we usually in legal circles call the general law, which is this idea that we had, I think, for about 100 years, where federal courts made this kind of common law that was different than state common law, and sometimes they contradicted each other, and it was okay, and yet it was in some sense just kind of the same thing we had in state courts, but at a national scale.
Yeah, so that's exactly right. And I'll just say in terms of background, in terms of where we're coming from, Danielle has written a lot about the kind of common law, and I think sees that as a kind of regulatory system that worked really well and still has a lot of applicability today, a lot of insights, a lot of wisdom over the centuries, and that we've kind of lost sight of that.
Which is generally Hayek's view at a 30,000 foot level as well. It's the utility of the common
maybe.
law.
I mean, it sort of depends on exactly where you think where exactly you think the rules are coming from. But I think in theory it really is the same thing as the kind of the general federal common law that courts were engaged in pre-Erie, 100 years ago when they would have commercial cases and they would reach conclusions about cases arising out of the similar facts and similar jurisdictions that were different from state courts. But we think it's important to understand what those courts kind of jurisprudentially thought they were doing and were aiming to do. Even if, look, in practice, they're making different rules, sure. But we think that at the time, both, state courts and federal courts were tasked with the same question, which was, again, answering the kind of general common law question about a particular situation, about a particular transaction. And the idea being not that there's this separately authorized sovereign lawmaking power, but instead that sometimes courts disagree with each other, right, about what the right legal answer is. And because you think of the general law as not just the positive law that's under the control of Pennsylvania, but instead is a kind of more general thing that you have to look to a broader set of sources for guidance, that the Pennsylvania Supreme Court could get it wrong. They could get the common law wrong, and in which case there's no reason why a federal court asking the same question should feel any obligation to defer, in the same way that there's no obligation for the federal court to defer to the Pennsylvania Supreme Court's interpretation of, say, federal constitutional law that it reaches for a case involving their jurisdiction, because the Pennsylvania Supreme Court is not the lawmaker, right? The law emanates from a different source, and courts can disagree, and that's just a necessary function of having a federal system with overlapping judicial hierarchies. And but post Erie, post the criticisms by Justice Holmes, we have this kind of positivist view, which is just that, oh, sure, courts were saying that they were looking for the rules that are out there, but they're just the lawmaker. And we think that that's not the right way to understand what the law as kind of a formal matter was doing and what it was aiming to do. Steve Sachs at Harvard, who's a friend, has written some really interesting stuff about this, about unwritten law, about common law that isn't under the control of one lawmaker. His metaphor that he uses a lot is rules of grammar and maybe rules of fashion, which are, there are rules that are out there, but there's not one person who has the sovereign authority just to command them. Instead, you have to kind of identify them by looking at various practices and weighing different sources differently to try to identify them. That doesn't mean there's no rules whatsoever. It just means it's a little bit harder and more complicated to try to identify what they are.
And does it also, I find in thinking about this area, does it also help to reconceptualize how we usually think about stare decisis these days, where, now we have this view of what courts say, as especially apex courts, the state Supreme Court or the U.S. Supreme Court, that what they say is kind of like a statute. And then that's the law. Mm-hmm. And, it's like they amended the statute when they, distinguish a past case or what have you. Whereas the old common law idea was, well, a court could say this, but it would be, maybe it was just kind of a little off. And then if courts keep saying that for a long time, then that is the common law changing over time. But you have to kind of look at the whole matrix before you get what the common law rule is.
Yeah, and I think you don't just say the rule is the same thing as what the court says, right? What the court says is evidence of the rule. What the court is doing is its own good faith effort to try to identify the rule. But they can screw it up. Mm-hmm. And the fact that the court said the rule is X doesn't conclusively settle the question. Now, as a matter of stare decisis, vertical and horizontal stare decisis, the lower court might have to defer to that and follow that as a matter of vertical stare decisis, and a court itself might feel some obligation to stick with the rule even if it thinks it was erroneous as a matter of horizontal stare decisis. But as a matter of kind of formalism, right? I think it is important to understand, and it provides a little bit of judicial humility to say that we don't make up the rules. We just try to discern the rules, and we can get it wrong. And then if we think we've gotten it wrong, there's a further question about, how to address that and, whether we change course. But, we are not lawmakers. We are law finders.
So one rule, some people might be wondering right now, one rule of the common law is that a statute, whether it's by parliament or a state legislature, can displace the common law, at least if they're clear about doing that. And so we, of course, live in an age today where there's umpteen statutes. There's still the common law, and they kind of interplay with each other and feed off each other in some ways. So any area, especially some of these new techie areas like drones, right? That's an example where there's like regulations, there's state, there's common law. It's really a mess, of course. Where your property ends and the drone's right begins. So, how does your model deal with the statutes, regulations in the same mix as the common law? Because then you're not just looking at cases; you're looking at. I mean, you said it's not like the positive law model where you actually look at the statute for jurisdiction, but still, there's a lot of statutes out there that are the law. So how do you go about that?
Yeah. So it's complicated. So you're absolutely right that, Parliament could, override the common law by passing a statute, and courts would have to follow that because of principles of parliamentary supremacy. That doesn't necessarily change the common law. It actually just overturns the common law, sort of supplants the common law in that jurisdiction. Here in the Fourth Amendment, it's different, right? Because it's a constitutional rule. Right. And it's a constitutional rule, the Fourth Amendment's protections, that a legislature can't just eradicate. They can't just say, tomorrow we've passed a new statute that says warrantless searches are fine whenever. And so we think that the task would remain for the court to discern the common law, general law scope of protection. And a statute is going to be relevant to that. It's going to reflect society's expectations. It's going to reflect all sorts of things that are relevant, but not dispositive. If it turns out that all 50 states have passed statutes sort of saying you have no interest in this that's recognizable at law at all, it becomes a little harder for a court to say the right answer under the general law today is that there's still this really robust privacy protection. It just means that no one jurisdiction can just automatically, by sheer force of will, supplant the protection. And we think that's an important thing. We think that, that's a real drawback of the Bode and Stern positive law approach, which is it just gives this power to legislatures to tweak positive law in a way, to make it the kind of tail wagging the dog to actually really water down or eliminate Fourth Amendment protections in different contexts. So
one case that this might remind a lot of people of, although it's a different context, is a last term's Supreme Court case about the lady who had her equity stolen from her. Right. So was
Tyler versus Hennepin County.
So it took place not far from where I live. Hennepin County takes this woman's home. It seems like she didn't have much of an argument that it was improperly taken for not paying property tax, but then they sell it and they keep the excess of the sale, which was quite a bit of excess. And there's many other cases where there's much bigger points of excess, amounts of excess. And so the argument is that the government had is that this is just the property law of the state, and so it's not a taking. And the Supreme Court, in relying on some precedents, said, actually, you could make that technical argument about the state of the law in Minnesota or whatever state you're talking about, but that can't override the takings clause because there's just general understanding of property law. So, of course, having explained it that way, it sounds a lot like general law of property that you might have for the Fourth Amendment. Do you see differences there? Is it kind of in the same space? How would you characterize, what your argument versus this takings kind of conception?
We liked that a lot. It came out after our article. was to the printer and everything, and so we don't really get to rely on it. But
Well, it allows you a follow-up article.
yeah. So maybe that's we should put that in the pipeline. But we thought that case was great, and it's really doing a similar kind of move, right? There's this provision in the Constitution, and we think it provides protection to property. The Fourth Amendment is very property focused, right? It enumerates
all kinds of property.
Houses, papers, effects, things that are property interests. And if you just say the scope of the protection are just totally creatures of state law, it really can make the protections of the Fourth Amendment a nullity. And the court has made a kind of something that looks like a general law move, both in Fourth Amendment cases and in Fifth Amendment cases, and it really does so in the Tyler case, which we really liked. The court says, look, if we just make it the scope totally dependent on state law, on any one state law, states can just eliminate the protections of the taking clause by saying, you have a right to this property except to the extent that the government has the right to take it whenever it wants. So the court says we look to not just the positive law of that jurisdiction, but to traditional property law principles plus historical practice and this court's precedents. We think that is exactly what courts should be doing in the Fourth Amendment cases, which is, sure, you look at the jurisdiction's laws, and those are an important data point. Those are not nothing, but you kind of would look to these kind of historical, big picture concepts of property law because we don't want to give any jurisdiction this power to just completely render a federal constitutional protection a nullity.
So maybe we can close on an area that I like to bore our listeners about, and that's state constitutions. So your argument, of course, is about the federal constitution, which we live in a federal system, the 50 states since the 14th Amendment, or at least should have been since the 14th Amendment, applied to the states in a general way. But just about every state has a version of the Fourth Amendment in their own constitution, a handful actually before the Fourth Amendment was drafted.
Yeah.
So would this model work at the state constitutional level, or is it just it would align with the positive law model? Like, what do you think? Do you think it is translatable to that level? Or do you think it at that point, it's not as useful?
I think it could totally work just fine, and it's going to be a matter of how that state's constitution works. I mean, so one thing to note is there are a number of states where the courts have said our state version of the Fourth Amendment is just coterminous with federal constitutional search and seizure jurisprudence. So they look the same, and ours doesn't provide more or less protection. And so we'll just piggyback on that. And in those states, presumably the analysis would look exactly the same. You just answer the Fourth Amendment question. But in other states, I think it's really going to be a question of what exactly that state constitutional provision is understood as doing. But there certainly would be nothing wrong with the state saying, we have this state constitutional protection. We think the scope of it should be determined by general law principles. States can tell courts to do general law. That's totally fine. And because it's a state constitutional provision, our own state's scope of statutory property rights can't, override the state constitutional protection. Now, a state could do it differently. It could say that, the way to interpret this is you look at, does this violate Minnesota property law? That would be okay too, because I think states, can make whatever constitutional provisions they want as long as they don't go below the federal constitutional floor. But I don't think the fact that law is being adjudicated by a state court means that state court can't be doing general law. And so some of the scholarship that we rely on is talking about how there are still actually some states where if you kind of read their law formally, they seem to still be, in general, instructing their courts to go out and find general law and not to just make the common law of that particular jurisdiction. That the formal thing those state courts are supposed to be doing is a general law type analysis.
So it could, I mean, your argument, it seems like it could be true to the state constitutional provision to look to general law, even though, say, the state itself might have a very minority view of, some property rights wrinkle or whatever it has, because there the state constitution is kind of calling for a different source of law than the state's own positive law.
Yeah. Yeah. And it's perfectly consistent with positivism to say this sovereign has told you to go look at some other source of law, right? A state constitutional provision could even say, the scope of Louisiana's protection against search and seizure shall be defined by reference to Mississippi's, right? I mean, it would be weird. You can't really imagine why they would want to do that, but there's nothing, illegitimate about doing that. If the state of Louisiana itself has made the sovereign decision to incorporate it. Now, that said, if you're in a state that has consistently said, we read the common law as not providing this protection, and then you're saying, well, in Fourth Amendment cases, could you also look to common law? Those state courts are probably likely to say, we also think the general law doesn't provide that protection because we don't think that's the right answer under the general law, the other thing. And so, there may end up be some, contraction there, but I think that you wouldn't just say, well, this state statute abrogated common law principles, therefore that automatically answers the general law question for purposes of a state constitution. That doesn't have to be the case. It could be, again, and that's just, and we don't, that's a great question. It's one that I think, don't touch at all in the paper, just because we'd have to do kind of the work to look at 50 different states' provisions, their content, their original understanding, their larger context, all sorts of things. And so all I'd say is that there's nothing stopping a state and a state court from recognizing this approach, and it may be the best answer for many, many states. But it's also, I certainly wouldn't take the position that the Fourth Amendment requires states to adjudicate their own constitutional provisions the same way. Could be totally different. I think that's just a question of constitutional meaning in those jurisdictions.
I'm tempted to make a joke about studies of 50 different state constitutions and how it takes a long time, considering my own experience. But I'll skip that. I have actually a final question that we can just muse about, which is, seems like the Supreme Court has gotten a little shy of the Fourth Amendment last couple of years, either this issue or any issue. Maybe that'll change for the coming term, which will have started, I think, by the time people hear this podcast. But what's your take on why this has happened? Is it like new justices, new alignments? They're trying to figure each other out, and what do you think that portends on this whole issue of the post-Katz interpretation of the Fourth Amendment?
Yeah, I really don't know. I mean, it could just be that there are, it's kind of random that in any given year the court doesn't grant that many cases, and so if the right cases that pique their interest don't come up, they don't grant them, and then maybe next year there are 4. It could be that some of the hardest Fourth Amendment questions are ones where we still need kind of what they call percolation in the lower courts, that they're hard and that we want more lower courts to weigh in before the court really answers them conclusively. There's hard questions. We talk about a little bit in the paper about poll cameras, right? If it's on public property, the court just sets up a camera on the light post or something, and it's not trespassing, but it's kind of recording everybody that's coming and going. Is that a Fourth Amendment violation? That's hard. It's hard under our approach. It's hard under Katz. And maybe you want to wait and see how those cases come out. Maybe the court has been so good about resolving all these little minutia questions that there's fewer and fewer kind of more traditional questions under Katz that courts need to resolve. I don't know. I think Orrin Kerr, somebody who might be able to tell us, whether there are fewer circuit splits than there once were on Fourth Amendment questions. I don't have an intuition on that. But I think that the length of time is short enough that we shouldn't make any firm conclusion that the court is not interested. If it goes on for another year, in which we've got a really extended period when there's not new Fourth Amendment law being made, when normally you'd expect 2 or 3 cases a year, then I think that's where we really need to sit down and say, what is going on? Maybe they're just too divided about how to, the larger approach in these cases, and they want to kind of wait and think about it. Maybe some of the newer justices just don't care about the issue compared to other stuff. They have a different agenda. That could be. I think it's just a little too soon to say. And so I'm certainly, as someone who teaches criminal procedure investigation, very much hoping there's some new cases, because I like teaching them, and I like, keeping my students up to date and saying, hey, there's this case that's going to come down in the next few months. Keep an eye out for it. It's going to be really interesting. I also like predicting what they're going to say, and I'm usually able to kind of figure out what they're likely to say in those cases. But I guess it makes it easier for me to teach. I don't have to adjust my syllabus at all year to year.
Well, that's a good point. Well, we'll keep a look on the calendar, and if a year from now we don't have more cases, maybe we'll have you back and muse some more about what's going on.
We can solve the mystery.
I think I like the hope that we're going to get some more Fourth Amendment at the Supreme Court soon, but that remains to be seen. But Dan, thank you so much for joining us today on Short Circuit. This has been a fascinating conversation about the two of my favorite P's in the pod, Fourth Amendment and general law. So best of luck on your next endeavor in this area, and very much appreciated.
All right. Thanks, Anthony. It was a great discussion.
And for everyone else, we'll see you next time. But in the meantime, I want everyone to get engaged.